Hello.
Hello.
Good morning and good afternoon, depending where you are in the world. Thanks everyone for joining us for this week's episode of Overdose and Chill. We are here with Michele Landis from Accessible360 today. Welcome.
Hello, welcome. Thank you for having me.
Of course. Thanks for joining us. So first off, where are you calling in from today?
Minneapolis, Minnesota. The flyover zone to some, but the epicenter to others.
And how are you guys doing with the weather this week? I know it's been crazy throughout, and I complain about it being cold in New York, but I'm fairly certain you're dealing with a bit more up there.
Yeah, we still put our kids on the bus when they go to school. If it's warmer than 35 degrees below zero, at 35 degrees below zero is when we say, okay, kids, don't stand outside anymore. So we're a hardy bunch here. It's been cold the past couple of weeks. But it's gonna warm up a little bit. It'll get above 0 or above 5 soon.
That's warming up. That's wild. I can't imagine. I am weak, I suppose, when it comes to that.
Yeah.
So thanks for joining us today. Certainly, I want to get into and dig real deep into compliance, ADA, and all the other things that are certainly relevant today for digital merchants. But before we get to that, please tell us a bit about yourself and your background and sort of where you come from.
Sure. So my background here at A360 is I've been here from day one. I have a couple really interesting and notable co-founders I'll touch on real quick. First of all, a gentleman named Mark Lasik. He invented frequent flyer miles basically back in the late 80s here in Minneapolis, Minnesota with a small airlines called Northwest Airlines. And then he went on to do all kinds of other digital loyalty programs. And so he's very well known in the agency world and that type of thing. Another very notable co-founder is a gentleman named Aaron Cannon. Aaron Cannon was born blind, became a full stack web developer. And when one of the biggest lawsuits, one of the first biggest ones hit here in Minneapolis with a company called Target, and awareness started to bubble up. Aaron was working at an agency as a web developer, software engineer. He could code in tons of different languages. And he represents what our auditors are like. So we have a team of auditors that are both blind and sighted, but all of them have a technical background. So prior to A360, I had worked with Mark on a couple of other platforms and that kind of thing. I started my sales career in technology with something that doesn't exist anymore, and that's called long distance. So I have twins that are 20, and I remember one of them asking one time, what is the 1 in a phone number for?
I remember, certainly growing up in the 80s, having to dial that 1 on the house phone, and how much trouble I got in because I was racking up long distance charges, calling literally the next town over because back then it was still that. So that's interesting. Okay, very cool. So A360 is firmly in the accessibility and accessibility compliance space, correct?
It is, yes. And how we're differentiated in this space is we're kind of way off to ourselves in that we're the first one that came in and really did full live user auditing. I think we'll talk probably about other solutions and stuff out there and how you test websites and mobile apps and Internet of Things and kiosks and all that stuff. But what we're known for is that live user auditing. I mentioned our team of auditors before. We have them spread out across the U.S. and they team up, both blind and sighted, to conduct our audits. And then we have a proprietary system where we log all the issues in, and they offer really concise and helpful recommended fixes. Because with this, you can have somebody tell you what's wrong, right? You can put a user on that says, "Hey, this didn't work for me." That's not that helpful when the developers need to fix it, right, and get it more into compliance. And so that custom recommended fix that we provide is really what differentiates us.
Sorry to interrupt you, Michele. So maybe let's start from the beginning, I guess. We're hearing more and more about ADA. It's been around for a while. It's somewhat newer when it comes to web properties and digital compliance. So maybe can you talk us through for both our US and our global audience, what is ADA?
Mm-hmm. Well, ADA stands for the Americans with Disabilities Act, signed into law in 1990 prior to the internet. So it did not, nor does it yet, have any language in it specifically speaking about digital properties. Doesn't talk about the web, doesn't talk about mobile apps for sure, or the internet or anything like that. And so for us or companies in the United States, the nomenclature has kind of taken over that it's ADA compliance. And where that comes from specifically is Title III of the ADA. And that is, to paraphrase it, it says that discrimination against anyone on the basis of a disability in a place of public accommodation is prohibited by federal law. So if you think about all the ramps and all that kind of stuff out in the physical space, that's what they meant when they wrote it. Of course, they didn't have the vision, right, of the world that we're all in now. So, and that was just not too long ago, really, right? 30 and a half years ago. So anyway, the thing to remember is that Title III of the ADA, a place of public accommodation, is what's used by plaintiff attorneys when they're bringing lawsuits against companies. And they've been very successful at it. It's hard to argue that the internet is not publicly available, or even apps and the App Store on your phone, Android or iOS, that those aren't publicly available. So that's what they're using. There is, in the United States, another law that actually does require digital accessibility for certain types of organizations. So if you're a company, you have to ask yourself, am I required by federal law, or am I being held accountable by use of another federal law? So the one that is on the books and that does require digital accessibility for government entities, healthcare, and public education is a law called the Rehabilitation Act of 1973. And it doesn't get the play the ADA does, right? But there were two amendments made back in 1998. The first one, a lot of people may have heard about, it's called Section 508. And that morphed into Section 508 compliance. But there's another one, Section 504. So two amendments to that law. One required government to be accessible in their documents and electronic transmissions, and that is Section 508. And 504 required it, it's an easy trick to remember it, requires companies that get funding, federal funding, for the activities and services and goods that they provide by federal law. So that's where healthcare and public education fit in. Does that make sense?
Yeah, I think it does. Are you a lawyer by any chance? Because you certainly you quote case law.
What's so ironic about that? And I wish my mom was listening, because she would say she was supposed to be a lawyer. I wanted to. I love the law. I teach continuing legal ed, ironically, on this, but I am not a lawyer. And nor does A360 ever profess to give legal advice to agencies or shared end clients. We always refer back. But we sit in this space, and we've had a really wonderful opportunity to work on several of the landmark cases, providing subject matter expert witness testimony. And so that gives us a lot of really cool insight, a lot of practical strategies, and kind of the best practices for risk mitigation. I did want to circle back to global. You asked me a question, what is this in the US and what is it globally? So the guidelines that we audit to are the web content accessibility guidelines written and introduced 21 plus years ago by the W3C, the World Wide Web Consortium. In our auditing work, that is the standard that we audit to. So whether it's a retail site in Italy or a software company in Australia, we're using the web content accessibility guidelines. We're also using them for mobile, because when they came out, we didn't have mobile apps either, but we did have the web. So that's kind of the evolution of that. Up in Canada, just our neighbors to the north, their laws are more provincially based. So based on which province you're in, and certainly the one that gets the most notice, I think, from my perspective, is Ontario. So they have the accessibility, Ontario's Act for, it's AOTA, sorry, I'm messing up the actual name of that one. But what I want everybody to understand is every province up in Canada has laws. And what they're trying to do up there is they're trying to reconcile and bring some standardization. So it'd be like in the United States, obviously every state having a different law. So they've been at it longer than us, really hitting the ground running back in 2015 with expectations for sites that are rolled out. At the end of last year, 2020, December 31st was the deadline, the cutoff date, at which point now in Ontario, you can be fined if you meet certain criteria, operating a website up there. And so that's pushing things. We have organizations like the UN who give statements on civil rights, and we have a dog coming into the podcast. And we also have, I was just doing some research on laws in Japan and what's going on, the EU directive for the European nations, and also just specific things in the UK. The biggest thing that I want to try and paint a picture of as far as the litigation that happens here in the United States and then what happens elsewhere is we don't have any yet amendments to the Americans with Disabilities Act, but we have all this case law, right? And it's overwhelming. What happens?
Can I just interrupt for 1 second on that? Because I think it's important to differentiate and understand, and I'm not sure I fully understand.
Okay, sure.
How is the ADA and the web content accessibility guidelines, how is that currently enforced in the U.S.? Does the government currently enforce it? Is it private citizens and groups? So can you talk through how that works?
Yeah. It's enforced by litigation, and that you kind of read my mind about where I was going. We have a very litigious society. You can sue anybody for anything at any time, in the glorious US of A, and you can get sued multiple times. So if you operate a website, say you have a retail store and you have a website, you can have one plaintiff attorney sue you in a district court in New York. You can have another plaintiff sue you in California. You can be sued multiple places. And so the stick, if you will, the enforcement comes by way of plaintiff activity primarily. A lot of it is high volume plaintiff activity. Now, there are some advocacy groups, right? Like National Federation of the Blind. There's a pretty well-known plaintiff attorney named Lainey Feingold. She doesn't do high volume cases. What she does is bring very structured agreements and making things better. And so there's a lot of attorneys out there doing that as well. So
to differentiate there, I think to what you're sort of getting at, first, that there's the civil suits that folks are bringing, and just sort of establishing, any reasonable human would appreciate and agree that that digital properties ought to be accessible to everyone, right? That goes without saying. So divorcing ourselves from sort of the social, moral, ethical issue of accessibility, let's talk about the commercials around that. And when we talk about folks who are out there actually fighting the good fight to ensure that digital properties are indeed accessible to folks, versus groups out there that may be frankly looking more for a settlement because that's a payout. So can we talk about sort of, that's what I think you're differentiating there, the people who are truly accessible and those who are just bringing lawsuits because there are merchants out there with deep pockets who you can target.
Yeah, and the end result is regardless of whether it whatever place it comes from, right? And I'm not going to sit in judgment of the place that it comes from, because as I've watched this over the past 5 years, the results are all just building the tipping point for zero acceptance of this, right? Very similar to what agencies went through when responsive web design came out. I was selling digital advertising back then, and we couldn't get things to scale on all the different size phones, and it was a nightmare for a while. And out of necessity, comes innovation, and that's wonderful. So COVID has been a huge accelerant to this. There's been a lot more awareness. There's been a lot more education, and also there's been a lot more success. People that run websites and mobile apps, they now know that they can work with an auditing company, that they can get the help that they need, which is an independent third-party audit, right? And then that they can have their wonderful agencies fix them, and that they can become compliant, and then everybody can be in the same audience. It's one of the kind of things we talk about internally here at A360. It's better when everyone's in one audience, right? You would never build a brick and mortar building and not put in the physical ADA requirements. You would put in a ramp. You would make sure you meet all those access points. More and more now, we're building websites, we're building mobile apps that are compliant from the ground up, and that's better for everybody. And so regardless of where the stick comes from or some of the carrot out there, the carrot part is organizations hear about this for the first time, and it's happened to me so many times, I can't even tell you, where, a VP of digital will be sitting on the phone and they've been in that job 10, 15, 20 years. And there's this pause and they say, I never knew anything about this. I never thought about this. I can count on my hand in 5 years how many people, once they learned about this, didn't want to do better. There were a couple of bad eggs out there, but otherwise, everybody, once they know better, they want to do better.
Yeah, no, absolutely. And I think, to your point, we're now at a place in the evolution of digital where more often than not, this is being taken into account, at the outset of a project, right?
Yeah.
How do we ensure that in building this, it is in fact compliant with these standards, right?
Right.
But the reality is there are many live properties out there that were not built with this in mind, right? It was for whatever reason cost prohibitive. Didn't realize we're just missed the boat on compliance and accessibility. How do those merchants, both domestically and internationally, folks trying to sort of selling into the U.S., as it were, as we hear more and more, daily, weekly, monthly of merchants getting these letters from legal firms, threat letters or whatever you want to call them, to how does a merchant get compliant? How does a merchant protect themselves while they are developing that roadmap toward compliance?
Yeah.
What are your thoughts there?
Yeah. And I speak on this a lot when I teach the continuing legal ed classes. It is, it's all about risk assessment. If you're a tiny company and you have a site on an e-commerce platform and you've got 5 products on it, well, can you afford to be accessible? We sure hope so. And we're all working towards that. The threat can come by way of a demand letter, which is basically a letter that says we're fixing to sue you, right? Mm-hmm. Or it could just come in a lawsuit, just right out of the gate. There is a trend that a lot of these lawsuits are filed in the state of California and in the state of New York for another particular legal reason, and they are state civil rights laws. So in the state of California, there's a law called the UNRRA Civil Rights Act. And that has with it particular access violation penalties and a recourse for getting your legal fees paid for. And so what I have seen as pretty typical behavior is that a plaintiff may access the website, 1, 2, or 3 times, and then they log those. And then when they file, they tell that story. So the state of New York has civil rights laws as well. So does the city of New York, actually. So I'm seeing that bubble up a little bit. So how do you become compliant, whether you are acting proactively or reactively, right, to a demand letter or a lawsuit? Proactively, the steps that you would eventually be held accountable for in a settlement, you could go ahead and start implementing right away, right? And that's why we do this with you guys, is that we help them post an accessibility statement. An accessibility statement doesn't say we're accessible. The accessibility statement says we're aware of the need of this, and we have other ways for you to get help while we're working on this. There's some steps that we've taken, like getting an audit and having our agency fix some of these things. And then making sure you have a phone number and or an email on there so people could get help or provide feedback. Those are really important. And then getting training or working with an agency that can provide the subject matter expertise, especially by way of a subcontractor like us, is great. And then, working towards it, logging all the things that you've done. It's a lot about keeping records. It's a little bit of governance. That's why our system is set up to do that. And then maintaining it. So if here, I'll throw an analogy at you. I heard you like those. When we start a project, we do the live user audit, and that's like the diagnosis of what's wrong, right? And then we put the digital product on a treatment protocol, a technical treatment protocol. And that is where we tell the agency developers exactly how to fix everything and how the client can maintain it on the front end if they're in charge of content marketing and things like that. So it's like, going to the doctor, getting diagnosed, getting on a treatment protocol, becoming well, and then maintaining that wellness. In this case, wellness is accessibility.
Cool. And I want to dig in a little bit on different approaches to accessibility and roadmaps toward compliance.
Sure.
But before you noted sort of how compliance is currently enforced in the U.S. Right? This is not, the government does not enforce it, unlike in other initiatives in other countries like GDPR, where governments do enforce that. And these are civil cases, meaning that if in fact the merchant opts to settle or to settle the case, there's there's no sort of jeopardy rules attached there. You can be sued again and again and again for those same things by other entities because this is not a criminal case.
True.
Yeah. So settling does not fix the issue, right?
It doesn't necessarily fix the issue. I wrote an article a couple years back about the game of whack-a-mole, right? And sometimes what we've seen is a larger plaintiff firm will sue, and then smaller ones may sue as well, or they might take a product apart. And by this, I mean, they might make a case based on the videos not being accessible, or the PDFs, on a school board website or something like that of meeting notes. And then they get around to doing the whole entire website itself. So one area of high concern for me that I tell people about all the time is the HR portals. So Title I of the Americans with Disabilities Act prohibits discrimination based on a disability in the hiring practices. And one real big miss out there is, companies say that they're an EEOC employer, right? They don't discriminate. They practice inclusivity and all this kind of stuff. Well, no, they don't, because people with vision disabilities, low vision or blindness, or a physical disability that can't do mouse operation but is using some other type of assistive technology can't even apply to work at that company. Or if they get in, the onboarding or the tests you have to take. So there's a lot of places where this really impacts the true lives of people with disabilities, and that they're not even allowed past that threshold. When was the last time you filled out a paper application? Or it doesn't exist anymore. And so you really have to be careful and think about it holistically at your organization. So one thing I did want to add, you were saying that the government doesn't enforce it. The Department of Justice has definitely weighed in on some of the bigger cases, the landmark cases, those advocacy-based things. Also, what they didn't do, and what we thought they were going to do for a period of about 8 years, was to make the recommendations about what the guidelines were. There used to be this thing in place called an advance notice of proposed rulemaking. And that's basically a list on the official executive branch of our government's agenda. It's literally on the agenda that they're going to do this. And then they kept kicking it down the road and kicking it down the road. And then they said, later, then much later. And then what they did, and it's not unusual really in business for the Department of Justice to step back and say, you know what, we're going to let the industry kind of evolve. We're going to let them just, establish best practices. And that's where, when I mentioned earlier, the case law comes from. So the district courts around the nation, they've tried these cases. Back in 2017, there was one judge in Pennsylvania where a lot of this got started. There's a plaintiff firm there called Carlson Lynch. There still is, and others nearby. But this one judge had hundreds of these cases sitting on the docket. And then all of a sudden in April, he ruled on a bank and like a racehorse track, because the racetrack, in my opinion, the racetrack had retail, it had hospitality, like you could book and you could buy tickets, and it had a lot of different types of functionality on the website. And then he picked a bank and he ruled on him, and he said, you've got to get going on this. And then there are some other landmark cases we can talk about. But what I wanted to mention about the government is there was another regulation or reporting law put into place, and it's called the 21st Century IDEA Act. And actually, ex-President Trump, prior President Trump, signed it 2 years ago. And it requires the government to report on their Section 508 compliance. So there's movement out there. And now you see the new administration, we do, of course, because it's near and dear to our heart. We see a lot of activity and a lot of proactive things with websites and, with different digital communications going on. So
maybe I'll rephrase that, which is the U.S. government does not actively police this, but they will weigh in on when things are exposed. So that's fair.
I think they'll weigh in, and they'll certainly, like I said, the DOJ does get involved in some cases, less and less. It seems more now, but
to your point, when you brought up the careers portal element of this, and sort of where it then sort of crosses over into civil rights law and the equal, employment practices. Mm-hmm. I imagine that's an area where actually, the DOJ may get more involved, because there's sort of it's a bit more, I don't know how to,
It's a bit more obvious.
It's a bit more obvious, and there is criminal case there, right? If you are actively putting up roadblocks, not intentionally, but you're actively doing it, then there could be grounds there for a case for employment law.
Yeah, there sure could. It's one where I'm surprised there isn't more activity, but these enterprise systems, right? So we talk about websites and we talk about mobile apps and Internet of Things like smart home components, like programmable thermostats. We've audited those types of things. And then you think about kiosks, like if you have a member of your family is a student at a university and they go to the lunchroom or commissary and they're ordering lunch there. So kiosks and those kind of things, all of the ATMs, right? Those are being audited and watched and all that type of thing. Fitness apps. A lot of the online stuff that happened due to COVID, we were just inundated, with people that were offering fitness classes online and signing up for those and doing a lot of broadcasts and things like that. So for a corporation, I would think about your external facing digital properties, but also I really want to broaden the thought process and think about how are you communicating with your employees internally? Are you using a fully accessible screen share system? Not every online webcaster or things like that or meeting platform is fully accessible. Some are more usable than others. And so that's important to pay attention to. And then, when there's simple things that you don't think about unless you have the, fortunate opportunity to work with people that have disabilities. So you can really see how, if you just pause when you're giving a presentation and there's a picture up, speakers at conferences, describe the picture real quickly. There's little things. There's things you can do on your own social media. You can add alt text and things like that on Facebook and Twitter and all that kind of stuff. So anyway. Well,
it's interesting, sort of segue into the next thing I want to talk about with you. But before that, for anyone listening, watching, by all means, drop in questions, comments. I'm sure Michele will be happy to answer those questions. And actually, before I get to this, there was a question. It had to do with sort of international standards and the UK Equality Act. Are you familiar with the UK Equality Act? Can you say a little bit about that and how that relates to WCAG?
Yeah, so we, obviously we don't deal with that here, but I did a big conference with the Corporate Compliance and Ethics Committee, and we had an attorney on from London on that one. So it was much more of a global appeal to this. And yes, they're tied in together. Yes, the WCAG standards, regardless of the country that you're in, are what the digital experts, agencies, and auditors use. There's always a couple of extra things. There's always a couple of, additional ways that they're going about introducing things. I see the EU and the UK getting more involved in the regulation of it. They don't have the litigious society that we do, but the irony over there is they've had laws on their books, like the one mentioned, for longer than the US has had the litigious action, right, and Title III. But they don't necessarily have more compliant apps or more compliant websites or anything either. In my observations, I often see some of the activity going on in Europe and in the UK a little bit behind us, in that they're starting kind of with scanning tools and they're trying these overlay widgets and gadgets and gizmos and things like that. And they're also doing something that we refer to as a so-called separate but equal website. And that is where you go onto a website and they ask you to kind of self-identify. They haven't fixed their core code, but what they say is, hey, if you are someone that has a disability and is using assistive technology, click here and have this other digital experience.
So I think to that point, sort of the next thing I want to get to is, I think when people hear ADA and compliance and digital properties, they know enough to know that there's alt text and there's font colors and contrast and things that I think are very, very basic. So I guess what is compliance? What is accessibility? And that's a bigger question. But we talk about the tools what are the tools that people are currently using to get their websites compliant, and how do you sort of view what accessibility is?
Sure. Yeah. So
and how are they different, right?
And how are they different? How have they evolved, really, right? So first of all, I think with any business compliance area where there's a lot of litigation, there's also a lot of opportunity. So there's been a tremendous amount of startups, in this space, right? The olden days, 7 years
last
ago.
year.
Yeah, 7 years ago. Accessibility is tied really closely with SEO. And the reason for that is when you're optimizing SEO, right, when you're improving SEO, you're marking up everything. You're making sure that every link is labeled, all the headings are proper and all that kind of stuff. Well, that proper semantic, HTML semantic markup is exactly what builds a really solid foundation for accessibility as well. And so they're closely related. In the early days, tools that were used to scan, a SaaS tool, right, a software as a service, a SaaS tool, or a bot, really is what it is, would scan websites for SEO. And those companies that had those kind of pivoted it and started marketing it for accessibility. In addition to that, there's been other tools developed just for the purpose of scanning or automation for accessibility testing. We have one too. I think every vendor does. We don't use ours upfront in the diagnosis. We use it more in the maintenance mode. You can use it to find some low-hanging fruit, if you will, but scanning tools only cover about 25% of the web content accessibility guidelines. And even many of those 25% need an additional manual test to see if it's correct. A super quick example would be alt text. No matter what that alt text is, a scanning tool is going to check that it has one. Well, the alt text could be completely wrong, right, or it could be completely useless, and therefore it's not compliant. And so what we talk about at A360 is both substantial conformance, right, or compliancy to the WCAG guidelines. And then we also talk about usability a lot. And the reason that we do is because in the simplest definition, what we're doing in our work is we're reconciling my experience as a sighted user who uses a mouse or tracking device with, say, one of my coworkers who's low vision or blind, and or somebody who doesn't have the physical abilities that we do, and also anyone that may suffer deafness. So the 4 disabilities that are covered are visual, low vision and other vision issues, including blindness, physical, cognitive, and auditory. So with the new guidelines that are coming out in 2.2, there's more focus on the cognitive things, which I think is really...
Right, and 2.2 being the latest iteration of the WCAG, or as you call it, WCAG?
Yeah, WCAG. So it was supposed to come out in November of 2020. It was delayed, like everything in 2020, it was delayed. And it's due to come out this summer. And so there's additional tests. It's just like when we went from 2.0 to 2.1. That leap was really about 3 brand new guidelines, mostly focused on responsive web design and new input modalities. And some digital products had it, some didn't. We audit to 2.1, but we also issue letters of conformance still to 2.0. Incidentally, the federal requirements for government, healthcare, and public education, those were refreshed from the old Section 508 compliance to WCAG 2.0. Level AA, and there's not yet been another refresh there, but all of our clients, all of our shared clients in those business verticals are operating off of 2.1 as well. So just a little bit of difference there.
Cool. Very interesting. I mean, it's an area where we're seeing, as I said, more and more activity, more and more merchants learning that they are not compliant, right? And the roadmap to getting there, certainly, I imagine you would recommend getting an accessibility compliance expert involved in a project upfront, during the roadmap, during the sort of discovery and architecture phase of a project, so that when you're doing the designs, that the experts could be alongside the partner designers, whomever's designing the site, to ensure that the designs are working toward accessibility compliance. Yes.
Yeah. Here's another analogy. You wouldn't build a new house and then we use sheetrock in Minnesota, but you wouldn't sheetrock your walls before you put your electrical conduit in. Right. So you put your electrical outlets in, you don't pick them after you finish the walls, you put the outlets in first. So when you're building something digital, put the accessibility foundation in as you're building it. And that's, to us, we love doing that because we're able to teach a lot, and we're a very mission-driven organization. So we want to teach as many designers and developers about this practice and building accessibility in as a foundation. Absolutely right.
So that's best case scenario. And having spent 7 years with the Home Depot, I understand there is new construction and existing construction, right? Your soffits and your cans, your lighting. So let's talk existing construction.
Okay.
There's a site that's live. We've talked about outside of, and it sounds like there is sort of a correlation between good SEO and, as you said, a good foundation for accessibility and compliance. Yes.
Yeah, absolutely.
And I imagine that because these firms that are contacting merchants about their failure to be compliant, maybe leveraging tools like that to go out and just scan sites, and it comes back, and if your SEO is bad, it's a good assumption that you may not be compliant at all. So it's just something I'm curious to know how these law firms are finding the websites to look at.
I think they certainly do use the scanning tools that are now marketed for accessibility. I certainly see that as well. I will also say that we have very few sites still that have become fully compliant. If we're doing hundreds or thousands of them, we're just barely nicking how many websites are out there, right?
Yep.
Yeah.
So then there are these, as you noted, overlay tools, or basically a completely separate experience where there is folks can basically rebuild their existing site into a new front end that is built entirely for to meet compliance standards as laid out by WCAG.
In theory, we can.
But certainly there are complications that I imagine with if you're doing updates to the site, what actually flows through to the new front end and all that. So I'll over to you.
Well, it's not only that, if you have an issue with your website, why would you duplicate it to attempt to fix the issue and then have to maintain two sites? Now that might be an agency's dream, right? But it's not most agencies we work with, and certainly not you guys. It's fix the core code, right? Fix it once and for all. The other problem with the so-called separate but equal sites is there's been some federal rulings on this. So Scandinavian Airlines did this with a vendor, and it was found not to be accessible. It's hard to keep it up, but also there is an image that I use sometimes when I teach on this, and it's a picture of a hallway from the 1960s, and you can imagine in a school. And so you can imagine what's in that hallway. There's some drinking fountains, and the whole thought is this: why would one human have to go through one digital door and a different human to use and interact with a brand? Why would they have to go through a different digital door? Why can't we just have everybody go through the same door and offer accessibility built in? It isn't. It's far from impossible.
I'm just saying, by its very nature, it's discriminatory.
Bingo! I knew you'd get there on your own. So it's a bad, in my personal opinion, I think it's a very bad PR move. And I think that's been proven out. In fact, vendors that kind of used to do that, the ones I know of, have really pivoted and they're going down what I personally think is a more truer path. You also asked about overlay tools. So let me describe the two types of overlay tools out there, and then you can ask me whatever else you want about them. There's a lot of really strong opinions out here about overlay tools in the world, in our world. There are overlay tools, widgets, plugins, pieces of JavaScript that you download, and they're marketed to magically fix the experience on the website. And magically, I mean, I'm using a marketing word there, but they say if you download this or install this, It will solve all your problems. The other type of overlay tool is a simple toolbar that does what your computer settings already do. They just put them in a nice, easy place. So if you think of like my 86, 87-year-old parents, they don't know how to go into the settings. They're not comfortable hitting Command plus. They don't have a Mac, but they're not comfortable with the stuff that we sometimes know how to do, or like developers do, and reverse contrast, their screen. Those toolbars that do that type of stuff, color contrast, make your font bigger, stuff your computer settings already do, that's a toolbar. That's not what I'm talking about when I talk about an overlay. The overlay ones are the ones that are pitching the idea that you don't have to fix the core code. We'll just fix it for you on the fly. I have yet to see one that I feel works as pitched. And again, that's just my personal opinion.
So, I mean, I know a big question out there is going to be, what is a timeline and cost to get
Sure.
compliant? And I imagine it all depends on how far away you are from the top of the mountain.
Yeah. When you start. Yeah.
Yeah. But I think, while merchants are working on those roadmaps with whomever they're partnering with on that, sorry, I got distracted for a second.
How fast can they
would you recommend them putting one of those widgets on to at least assist folks who may need larger font or may need higher contrast? Is that something that's a short term, not a solution to getting compliant, but if it's going to take you 3 months to get there, is that an immediate fix to allow folks to access the site more easily? I
personally don't see any harm in the toolbars. What your computer already does.
Yeah,
it makes you feel better.
Okay.
Is the bottom line. And here's why I say that kind of in jest or kind of like, off the cuff, is that you have to understand that people who benefit from universal design, accessibility in design and development, they're going to access a website or a mobile app with their own assistive technology already in place. And so again, back to the idea of like a company that used to sell the idea that, hey, we'll put a screen reader on your website, so in case a blind person wants to use it, they can use it. Well, did anybody ever stop and think in that story, how would the blind person get to that website before turning on the screen reader that somebody's going to sell you to put on? Yeah. They wouldn't, is the answer. They, desktops and laptops, they use JAWS or NVDA. Windows has narrator, but it doesn't have a very large market share at all. And of course, on mobile devices, it's either VoiceOver on iOS or TalkBack on Android. So if you are blind, like a lot of our auditors at A360, you're already have that assistive technology engaged. The agency's job and the brand's job is just to make sure that their underlying code works across a myriad of different assistive technology. It might be a screen reader, might be a sip and puff. If you've seen someone in a wheelchair that's paralyzed from the neck down, you can, think of Christopher Reeve and how he operated the web was literally by inhaling and exhaling to simulate one keystroke. It's fascinating. We have tons of videos up about it. So if you've never listened to JAWS, if you've never heard a screen reader in action or any of that, I really encourage you guys to immerse and look at some of that stuff. We have a YouTube channel that has some of that stuff up, but it's all over. So
it's interesting. I saw a couple of years ago, it was, I think it was HSBC, or maybe I'm giving a shout out and they didn't deserve it. I forget what bank it was, but they were redesigning their ATMs. Mm-hmm. And they made these suits, these like body suits for their testers to wear that had like weights on them and had impaired vision, all these things to simulate what sort of the, a target demo of say 70 to 80-year-olds, generally may be up against. They videotaped the whole exercise of these folks really struggling to use an ATM because they could only move so quickly and they couldn't really see. And it was really, it was really eye-opening to sort of see what is really required to create a thoughtful experience for folks that it's very hard to relate to if you haven't experienced it yourself.
Yeah, there's a phenomenon, right? If you're a UX, I used to do a lot of UX consulting. If you're looking at stuff and you've been looking at it forever, you send it to a buddy or your girlfriend or somebody, outside and be like, hey, take fresh eyes on this. You become a little accustomed to stuff that you're not paying attention to. And so doing studies like that full usability study, we've done some really cool stuff on kiosks like that. And then we partner with another firm to do those in hospitality venues. So they're doing the physical test, like, can I get into the property? Is the room really accessible? And that type of thing. And then A360 is doing the digital part. So
cool. I have one more question, although this may go deeper than we need to right now, maybe a topic for another conversation. But when it comes to sort of strict liability or any liability, if I'm a merchant and I'm leveraging a host of third-party SaaS technologies as part of my tech stack, where does your liability as a merchant end and that tech platform begin if it's like an in checkout technology that you have no control over the front end of it or what have you?
Mm-hmm. I'm so glad you asked this question. I thought about it earlier, third parties. I was going to mention it. Happy to go here. First of all, when you're signing a contract with a third-party vendor, there are 3 different types of contract law. You can, as it relates to compliance, any type of compliance, you can either say whatever we're held accountable for, you are going to be held accountable to. So you have this yard, which is the website, and you're inviting people to come in and participate in that yard, and they have to, abide and play by the same rules that everybody else does in the neighborhood, right? Another type of contract law would be specific, where you say you are going to be held by this specific standard. And then there's also pass through. So 3 different types of contract language. First and foremost, read your third-party providers' contracts and find out, ask them, have you had an independent third-party audit of your website? We're starting to see a lot of third parties come through A360 because of the vast, huge amount of retail sites that we audit. But even across all business verticals that we work in, those third parties keep coming up, calendar widgets and booking engines and things like that. And so inevitably the story at A360 goes like this. We audit, a client of your sites, and they have these third-party things on there. And then the client shares the information or some of the information, or the conversation starts about, what are you doing about this? And we have a wide range of client attitudes at A360, and some are very strong-handed, and they're say, you get a live user audit and you give me a letter of conformance, or I'm not going to let you in my yard. Others, we're evolving this. So what I've been telling people the past 2 years is, when you re-up that contract, put some pressure there, right? So we have a whole list of people that we know are really, really good at things like what chat functions work, what reviews, what, redirect marketing, what search engine stuff and all that. We're on the inside, so we're a great resource, to talk through those different things. And what I see is very encouraging. I see a tremendous amount of third-party people getting their stuff done and getting their house in order. Why wouldn't they? Because if the train's left the station and they're not on it with a car that works, where are they going to go? Where I see more of a problem, actually, Andrew, is more on the foundational level. So if you think about our yard, like what's going on the ground level, and those are things like school platforms, the e-commerce platforms, I think, are doing a much better job. FinTech, if you're building something on top of a chassis, and that chassis isn't accessible, then whatever is built on is never going to be fully accessible. And that's where I really want to see a lot of movement and action. And those are the ones, particularly in my personal opinion, where I think some more emphasis should be brought, right? Like if you're a school and you get your website from this platform and then you're sued because of it, well, that's your question, right? Where does that go? There's one case in particular that ruled on this, and I'll talk a little bit about it. It's certainly not a federal law, but with all the attorneys that we work with at A360, a lot of them are starting to adopt this. And it was the Winn-Dixie case down in the Southern District of Florida back in 2017. That was the first ever trial for digital accessibility, and that it brought forth 3 other really important rulings. Number one, that judge said that WCAG 2.0 level AA at the time is the standard. And so that was a first. He also dismissed their motion to dismiss, or denied their motion to dismiss the case based on a financial undue burden. And I love telling this story because the grocery store had just implemented a reward system with a very big bank, and they paid a ton of money, millions of dollars, to implement it. And then their argument was, we don't have $50,000 to make the website accessible. A complicated website. So that was dismissed. And the other thing that judge said was that you are 100% responsible, Winn-Dixie, for the third-party providers on your website. And that kind of little shock waves all over the place, right? It's not federal law. It's what happened on one case. And please understand, too, to put it in context, 90% of these cases settle within 2 days to 2 months. Very few get into the court system. The big landmark ones like Blick and Barbary and Domino's and the Winn-Dixie, those are, that's not common. Not a lot of people, litigate that far. Most of them settle a lot sooner.
Yeah, and I've gone way past the time that I thought we would, so I really appreciate your sticking around. I think, end result is it's an important item right now, certainly on and will be going forward on websites. It's complicated. There is no quick fix. There is no overnight fix for this. It goes beyond what does the front end of the website feel, look like. We're talking about what are your marketing initiatives? What's your email look like? What's your social media? How does that integrate? accessibility and compliance, applies to all of your digital properties. So absolutely an area where merchants ought to be digging in and finding and developing their roadmap to get compliant, because this is not going away, and certainly nor should it, because frankly, as we talked about at the outset, websites and digital properties should be accessible to everyone. So what is the most efficient path to get there? And that's the nut to crack, I suppose.
That's the thing. Yeah, choose wisely, right? Spend money wisely. There's a lot of free tools out there that you can run for color contrast, and you can even check some of the low-hanging fruit. So my advice is this, in a nutshell, if I can summarize, is any money that you spend towards digital accessibility, spend it on a live user audit. Make sure that you think about it when you're building new things. You asked about strawmans before. You can get solutions starting, an audit if you want to, anywhere between probably $5,000 and $25,000, depending on, what your site is or your mobile app is and that kind of thing. But ask good questions, work with reputable vendors, ask for references. What have they done? What's the street cred like? And I love your point more than anything. There's no quick fix. It's just like fitness every day. You're either making good decisions or you're making bad decisions. And so the best thing you can do is get started. And that's what I hope everybody does.
Absolutely. And just to reinforce what we talked about earlier, which is when you do get started, you are able to publicly note that you have a roadmap in place to get compliant. Mm-hmm. And that's something that will certainly, from a liability standpoint, help at least give you some time to get there without having to be fielding demand letters and threat letters on a daily basis. So just get yourself protected and get where you need to be. Thank you so much for joining us, Michele. Really enjoyed talking with you as always. And I'm sure we will talk soon, but
great.
Have a great afternoon.
Thank you.
Thanks for great knowledge.
All right. Thanks for having me. Take care.
Bye.